So a little bit about my organization. I'm a staff attorney at Bridge to Justice. We're a nonprofit legal service provider. So we offer a mix of pro bono, so that's free, and low bono representation. So our low bono rates are 125 or 145 an hour for any type of law that we don't have grant funding for. Right now, we currently have programs doing extreme risk protection orders. So that's pro bono, that's free. So if anybody in Colorado needs an extreme risk protection order attorney, they can come to our organization and we'll try to connect them with one of our staff. Civil protection orders, eviction defense, public benefits, and family law. So if you have anybody that wants to access our services, the best way to do that is through our website, through the Contact Us page, but we also have this phone number in case people don't have access to a computer. All right, my co-presenter here today is Jeremy Shufflebarger. Would you like to talk about yourself, Jeremy?
Oh, sure. So this is my blurb that's on my website, but I'm an attorney in Fort Collins, Colorado. I practice, I represent mental health professionals throughout the whole state of Colorado. And I've been doing that actually since I was in law school. I used to work and help out an attorney who did this work. Some of you may recognize the name Dennis Lane. He's since pretty much retired. Every once in a while he takes on some stuff. But you know, mental health defense and especially dealing with DOR and so on has always been a part of my focus. My wife's an LMFT. She's been doing it for 20 years. She also supervises therapists, so I kind of have feet in both doors there. And then I'm also the agency attorney for 2 adoption agencies, and I do family law cases. That's relevant on the family law side because it's good to see both sides of this. It does create some conflicts once in a while. But being able to see this actually in practice when someone's involved in a high conflict custody case and, you know, having them be a mental health professional, seeing both sides of it can help and how judges handle it. So yeah, there we go.
And is your website or phone number the best way to reach you? Okay. I didn't check with you before making that slide, so thank you for clarifying. Okay, so we're going to dive into overviews of ERPOs, and we're going to be using some terms pretty frequently when we talk about these. So I want to clarify, I want to define those for you. A respondent is the person who is exhibiting at-risk behavior. They're the person on the other side of the aisle whom we're seeking to have firearms removed from their possession. The petitioner is the person who is asking the court to issue an extreme risk protection order. Service is when law enforcement physically hands the respondent paperwork. So they hand them the court orders and any other paperwork that is ordered to be delivered by the judge. And standing is when somebody is allowed to file. It's when, you know, you're part of one of these classes of people that is allowed to file for protection order in Colorado. So here's the kind of meat and potatoes of extreme risk protection orders. ERPOs are designed to address situations where the respondent poses a significant risk of causing personal injury to self or others by having in the respondent's custody or control a firearm, or by purchasing, possessing, or receiving a firearm. So there's a lot of interpretation that can be done on that language, but some things that I've learned from reviewing the cases that have been filed in Colorado around these is, you know, the threat itself doesn't have to explicitly mention a firearm. So the example I have here, if somebody's saying, I want to kill my roommate, that is likely sufficient to obtain an extreme risk protection order. It is unlikely, based on the cases that I've reviewed, it is unlikely that a judge would require the statement to say, I want to kill my roommate with a firearm. I don't think that piece is necessarily a prerequisite for getting an extreme risk protection order. I'm sorry, I was reviewing in chat. In Colorado, ERPOs have been issued to address suicide threats, homicide threats, threats against institutions like businesses, schools, sororities, etc. Threats presented by a clinically diagnosed delusional mental health disorder, such as schizophrenia. I've seen cases where There's been concerns, a particular respondent is seeing phantom people, and we're concerned that their access to firearm might endanger others. And threats presented by reckless discharge or improper storage of firearms. I've seen 3 or 4 of those cases. They typically involve substance abuse coupled with the reckless use or storage of firearms. And so the question is, how do ERPOs address this risk, right? So they demand that the respondent, once one is entered and served on the respondent, they demand that he immediately surrender to law enforcement all firearms in their custody, control, or possession, and any concealed carry permits issued to them. They also make it a crime for the respondent to have in their custody or control a firearm, or to purchase, possess, or receive a firearm while the order is in effect. If the respondent violates the order, they commit a Class 2 misdemeanor, punishable by up to $1,000 and up to 12 months in jail. The respondent's name will appear in the NCIC database. And so this is the database that licensed firearm dealers reference before selling a firearm. One important thing to note about extreme risk protection orders, they do not prevent the respondent from contacting, approaching, or retaliating against the petitioner or any other third party. In Colorado, we frequently see civil protection orders. Those are the types of orders that restrain the respondent from doing those things, filed alongside ERPOs. So ERPOs are just about possession of firearms. They don't go into saying that they need to stay away from anyone they've threatened. So first, we're going to talk about the duty to warn. This is the first step that you guys need to evaluate when you have a patient who is discussing a harm to themselves or others. Jeremy, do you want to maybe take this slide?
Sure. And I think that's the important part about this for mental health professionals to remember that ERPOs are an extension of the duty to warn, where the danger or where the conduct will first lie is whether or not somebody has been threatened, a specific class of person. So what the duty to warn is now, and that's been revised, but this is the language as it is now, is that when a mental health provider receives a serious threat or has communicated, their patient has communicated a serious threat of imminent physical violence against a specific person or persons, including those identified by their association with a specific location or entity. We're talking really about a church, a school, something like that. The mental health provider shall make reasonable and timely efforts to notify the person or persons or the person or persons responsible for specific location, blah, 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 as well as law enforcement. That's the important part here, is that if something like this does occur, you have 2 responsibilities, not just to notify the person that's threatened, but it's also to notify law enforcement. And this is really where the ERPO would stem from. You would have this as kind of the predicate action. They do something that's very scary, and you know that they have access to firearms or plan on purchasing firearms to maybe follow through with the plan. In terms of the word imminent, this is always a question. What does imminence mean? Well, it can mean something different in a case-by-case basis. Typically, what we see, most judges will interpret imminent to include the next 2 to 3 days. So they can't be saying, hey, I'm going to go, kill off everyone in the school next year, right? That's not the imminency we're talking about. We're talking about them saying, tomorrow I'm getting up, I'm grabbing a gun, and I'm going to go in and mow down everybody in school. There needs to be some kind of temporal aspect to the threat that they're making. And then it's important, of course, to remember it has to be against a specific identifiable person or entity. It can't just be something general that I'm going to go outside and kill everybody I see. It needs to be I'm going to go and, take a gun and I'm going to go shoot up this specific place or these specific people.
Yeah, so.
Yeah, go ahead, Rachel.
Yeah, I think we went over most of this. So the likely first step, the duty to warn, once you've evaluated, once you've heard something from a patient that is threatening to themselves or others, The likely first step, if you feel like it meets the imminency requirement, you feel like it checks all the boxes for duty to warn, you want to reach out to your area crisis response and or law enforcement. I know in Boulder County, we have a co-response model. So most of our law enforcement goes out with the crisis response team. And I believe they kind of take the reins on a 72-hour mental health hold. Is that correct, Jeremy?
Yeah, that's so in Larimer County, it's the same thing. They have a mobile crisis response team. And so, what I've been advising all my therapists do that come and talk to me about this, traditionally some therapists had to be in the role to start the 72-hour holds themselves. Well, that's for any of you that have actually done it, it's a huge pain to go through that process. So these mobile crisis response teams, they are geared to do exactly this. They're also well suited for it. So typically in the past, you'd sometimes have law enforcement show up. Well, they're not always the best people to handle this kind of stuff. So these mobile crisis response teams know how to handle and diffuse situations and then initiate the 72-hour hold and go through the paperwork. And so that's usually what I advise people to follow through with. The one thing to remember though is if your client were to leave before you can do a 72-hour hold or have the mobile crisis response team show up, then your duty to warn has been triggered. Essentially, you need to make sure you're contacting law enforcement and the person that's threatened. But ideally, you would get the 72-hour hold to take care of it before any of that happens.
And so if you believe an extreme risk protection order is appropriate, you may encourage law enforcement or someone, if confidentiality allows. So let's say if that duty to warn was triggered and you had to warn, a family member who may be in danger, if confidentiality allows, you can tell them about the process for an extreme risk protection order. So Boulder County has had 24 extreme risk protection orders in our case since the law went into effect, and I reviewed all of them. 10 of them were filed by private individuals, family members, household members, and almost all of those 10 people cited, somebody else encouraged me to file for this. So extreme risk protection orders are not typically filed out of the blue. It's not a very well-known process, and it's not really on anybody's radar to the degree we'd like it to be. So even if you decide, it's not appropriate for me to be the one filing, which we completely understand, you are in a position of trust and advocacy. And if confidentiality allows, I do personally think it's appropriate for you to say, I hope an extreme risk protection order gets filed. As I mentioned, Bridge to Justice does these cases for free. If you feel like it's appropriate, you're welcome to disseminate our information when making those referrals.
And if I may jump in here.
Oh, sorry.
Yeah, just to make it clear, I know we have the 12-year-old consent law in place now, and then there's also the 15-year-old consent law. Remember, each of those has a specific provision in it that allows you to notify family members, well, specifically guardians or parents, if you feel it's necessary. The exact language is the professional, this is for 15 years and older, but the professional person or licensed mental health professional rendering mental health services to a minor may, with or without the consent of the minor, advise the minor's parent or legal guardian of the services given or needed. So in that kind of situation, you could still inform the parents, even if your client who's 15, 16 years old doesn't agree.
And this stuff is complicated. We're really doing our best to make it as user-friendly as possible. But, I've been an attorney for 9 years now, and I was diving into this, and it was confusing. I really needed to talk to Jeremy. So this is not user-friendly stuff. This is not easy by any means. And so when in doubt, we would encourage you to speak with an attorney about these things. Obviously, imminent safety concerns, I think, are kind of a priority, but when you have the opportunity, if you have that space to reach out to counsel, it's completely appropriate.
And if I could jump in on that part, in terms of reaching out to counsel, remember, most of your malpractice insurance policies have a provision in there to allow, well, CPH, for instance, has a provision there to allow for 2 hours of free legal consultation per year. The other thing to keep in mind is your insurance companies will force you sometimes to try to work with an attorney. You can tell them you're already working with a specific attorney. So if there's someone you like to work with that's not specifically paneled by them, they still have to cover the costs. So just remember that you're not stuck with whatever attorney they give you, because sometimes they'll give you an attorney that is, familiar in medical Dora dealing with the medical profession, not mental health profession. Well, they're vastly different. So keep that in mind.
Absolutely. And just a quick note about law enforcement. So law enforcement, like I said, in Boulder County filed 14. So the majority of the extreme risk protection orders that my area has seen. When organizations have looked at the success rate of ERPO petitions, law enforcement is much more successful in getting these orders. If it is possible, if you have a law enforcement officer that's willing and able to file for these, I think that's the ideal scenario for everybody involved. But law enforcement officers are people that, just like you and me, sometimes they get it correct, sometimes they don't get it correct. And I would just encourage you in a situation like that to trust yourself. You likely know your client exponentially more than a law enforcement officer does. So if you're in a situation where you feel in your heart that somebody poses a risk and law enforcement saying, don't worry about it, or they don't do ERPOs in their area, that might be a situation where you should consider filing yourself. And so I just want to remind everybody that Colorado has a majority of the counties in our state have designated themselves, quote unquote, Second Amendment sanctuaries.
I'm in a
Yeah,
webinar.
I'm on it too. What are you doing for lunch?
Miss London, your mic is not muted. And everyone might want to make sure that their mics are muted. There we go.
Perfect. The lunchtime webinars always have a little bit extra of that in them. So here's a map. This is the most recent map I've been able to find. This is a pro Second Amendment sanctuary website that, goes through the different counties in our state who have, at least at some point as of 2021, declared publicly that they're Second Amendment sanctuaries. And that means everything from they will categorically not file for extreme risk protection orders, or they're claiming that they will refuse to file. Some have even claimed that they won't serve or enforce ERPOs. But basically there are a lot of biases. There's a lot of really strong feelings about this issue that could, divide people. You guys might feel like an ERPO is appropriate, whereas law enforcement doesn't. And that's not necessarily an objective reflection of the risk that this person is posing. So again, I would encourage you to trust your judgment.
And on that note, I think it's important to understand, depending on which county that you're operating in or seeing these clients, could determine how law enforcement responds. Just like Rachel's talking about with these sanctuary counties, it may be that they will not move forward with it, or they may pretend to move forward with it. So knowing whether the county is a sanctuary county or not could be important. If you're really concerned and feel like, hey, I need to move forward to make sure the ERPO goes through, or at least the petition is put through and something's done. There's judges that literally have to hold sheriffs in contempt to make sure that they're enforcing these. So sometimes it requires more action in the case. And in a situation like that, you would literally put into your petition, law enforcement refused to do anything about this. Okay.
So now we'll talk about standing, and we've kind of touched on this a little bit. So not everybody is allowed to file for an extreme risk protection order. You have to fall into a particular category depending on your relationship with the respondent. So first thing is to address a question I've been getting a lot. You do not have to file for an extreme risk protection order. Some of your obligations as a mental health professional or medical professional are mandatory, like mandatory reporting laws or duty to warn, et cetera. Filing for an extreme risk protection order is optional. There is language in the statute that is meant to protect your decision to file or not file. And Jeremy will discuss more about that in detail. But as of April 28th, 2023, so this is a very new change, certain medical and mental health professionals are able to file for ERPOs in Colorado. To do so, you must meet the definition of quote unquote community member. That's the language in the statute. That means a licensed healthcare professional or mental health professional who, through a direct professional relationship, provided care to the respondent or the respondent's child within 6 months before requesting the protection order. Included in community members also educators who have, a similar relationship to the case. So there is a specific, definition of who is a licensed healthcare professional, and that's included here. Again, I'm going to make these slides available to everybody after the meeting. And so it's kind of a laundry list. If you meet these requirements, then you have, you qualify under the statute. Mental health professionals, a much more extensive list. We have certain licensed individuals, psychologists, licensed professional social workers, marriage and family therapist, licensed professional counselor, and addiction counselors with certain registration and certification requirements. It also includes candidates for certain licensures as listed here. And then there's kind of some miscellaneous folks that were in there as well. At least that's how I'm conceptualizing them. Specific school counselors with particular licenses and endorsements, school social workers, school psychologists, and unlicensed psychotherapists registered pursuant to statute. So I've had a lot of questions about this last one. My advice has been to go on DORA. If you're registered, I believe that it will show up on DORA. Is that accurate, Jeremy?
And yeah, basically what it is, if you have any kind of registration through DORA for mental health work, this would cover you. This is what it is. An unlicensed psychotherapist, Colorado is one of the few states out there that allows people to practice therapy without being fully licensed. And there's a lot of people that do that. It has a specific provision within DORA, but it's still covered under DORA. Hence, it's still covered as a mandatory reporter. It's still covered as under the ERPOs. Still be covered for duty to warn.
So here's just kind of the summary. If you're evaluating whether or not I am legally allowed to file for an ERPO in my professional capacity, the first question is, do you meet the definition of a licensed healthcare provider or healthcare mental health professional? The second one is through a direct professional relationship. So, if somebody says something to you in the grocery store, that's not enough for you to file. It has to be through that professional relationship you have with an individual, and that you provided care to the respondent or the respondent's child within 6 months of requesting an ERPO.
And I'm going to jump in really quick here, Rachel. We had a question. How about a licensed supervisor of a university clinical intern? Supervisor relationship would fall under a professional relationship. I don't think there's any way to get out of that interpretation. So if you're a supervisor of a, whether it's a candidate or whether it's an intern through the university, if that's your role, as long as you're a licensed mental health professional and you're in a professional relationship, which that would qualify, then that would trigger it. But remember, once again, this is not a mandatory requirement, unlike a duty to warn or mandatory reporting for child abuse or neglect. This is permissible, not shall.
And, we talked about encouraging other people to file. And so I think it's important for you guys to know who else can file. First, family members, and that is defined very broadly in the statute. This is anybody related by blood or marriage, anybody with a step-parent relationship, grandparent relationship, anybody who's been a legal guardian, anybody who's had an intimate relationship, so dating partners, past dating partners. Family member is very, very broadly defined. I think most people have a good feel for, family or not. Household members is another category. And so these are people who have regularly resided with the respondent in the past 6 months. So roommates, they don't have to be part of like the tax household or anything like that. It's just somebody who's, resided with the respondent. Law enforcement may file. They've actually enlarged who can file under law enforcement to include district attorneys. I've seen a lot of individual officers file. I've seen a lot of entire police departments file. We're filing as an entity. And then educators. A quick note about educators. They're really kind of the traditional sense of the word educator, people with they're at accredited schools and stuff. There is a similarly kind of restrictive definition for educators in the statute. So, there's a lot of people I would consider to be educators that won't meet this definition. So if you're interacting with anybody like that, it's a good thing to keep on your radar. All right, confidentiality. All right, so let's say you've exhausted all other resources, nobody else is addressing the situation, and you decide, unfortunately, I do have to file for an extreme risk protection order. Talk about what you're allowed to disclose. So the statute says, as necessary, you are authorized to disclose protected health information in this process. However, you want to make a very concerted effort to only release the minimum amount of information necessary. So just because one or two statements are relevant to proceedings, you don't necessarily, that doesn't mean everything that that person has ever said to you is now not confidential. You really have to make sure that you're keeping a tight grasp on anything else. So you want it as little information as possible. So you actually have affirmative obligations to make sure that you're doing that. So consider doing things like redacting documents, only releasing part of documents. If a judge believes that more information is necessary, they can order you to give more information. So for me, when I review that statute, I would err on the side of, I need to communicate this risk to a judge who has no background in what's going on with this individual, but I want to really just not give as I want to give as little information as possible.
Which is interesting, Rachel. I'm gonna jump in here because I think where this becomes problematic is oftentimes this will be tied with a duty to warn. And so what we're really talking about is a situation where you feel like the duty to warn came up. You understand that this client has access to firearms or is going to purchase or has a way to get them. And then you contact law enforcement because that would be the first step, right? But if law enforcement won't do anything, then you're asking to do it through an ERPO process. So then the information that you're revealing is technically already been revealed to law enforcement. Plus you have to have an underlying basis besides just having the firearms present. So this one is going to be a mess. And this is why I would say you certainly want to talk to an attorney before moving forward on an ERPO, because it's what is the necessary information? What's the minimum necessary? I absolutely hate that language. Because I think this is really going to deter a lot of mental health professionals from wanting to move forward with an ERPO because of the way this language is worded, not to mention what we're going to talk about here.
Yeah, so there's language in the statute that is clearly intended to protect you guys if you do have to move forward and you do have to disclose patient information. These two words, so the goal, the intention is to protect you as long as you're making the decision reasonably and in good faith. Well, those two terms are job security for attorneys because they are very ambiguous and super prone to litigation. So sometimes we're interpreting a word that has a very clear-cut black and white definition and there's not a lot of litigation around it. Everybody knows what it means. Reasonable and good faith are incredibly open to interpretation, and not a lot of people agree on what constitutes those things. So we're not trying to talk you out of filing for an ERPO. That's not the goal of this presentation. But we do really want to communicate to you that if you do decide, it's not a risk-free process. It's a very important process. I believe very strongly in ERPOs. But I do want to make sure any professional that is moving forward with these protection orders is doing so with open eyes, that there are potential risks for you in engaging in this process. And so if you move forward, we're minimizing the amount of information. The court will do things like place limits on who has access to the case file. They will issue a gag order prohibiting the parties from, using any of that protected health information for unrelated purposes.
And I think that's an important thing to note. So that provides a little, I don't want to call it promotion for ERPOs, but in terms of knowing that this is not just a blanket waiver of confidentiality, it's not going to just allow that information to be released anywhere. If that information is included in petition for an ERPO, there's a very specific process the court has to follow. They issue orders to make sure nobody's revealing this information outside of court. They actually have things in place that require them to destroy it in certain situations, to make sure it's sealed and no one else can access it. So that's at least the good part of this, is if you did have to go forward with this, even if someone tried to argue that, hey, you've been harmed because you revealed the confidential information, that damage is very limited because of the process of the ERPO itself.
I mean, do you want to talk about this next slide? It's really more in your wheelhouse than mine, maybe. Better.
Yeah, so what happens if you're contacted? So Rachel and I were talking about this. I was trying to think about what situations would this arise for mental health professionals. So obviously the one is the one we've already talked about, where you decide to file on your own. In that kind of situation, then you move forward on the process. So this stuff is not going to apply. This is more so a process where someone else, let's say a family member or somebody, go ahead or moves forward with an ERPO, and then you get contacted about this by someone, law enforcement or somebody saying, hey, you know, we have this process going, we need more information. You know, what do you do when you're first contacted? Well, the very first step always is if you don't have a release, your first answer is always going to be, I cannot confirm or deny my treatment of any individual without a subpoena, release of information, or valid court order. That's always going to be your response, regardless of who it is. Now, if you receive a valid subpoena, or a valid court order requiring that you reveal information or talk, that's a different story. If you get one of those, then your first step is to be contacting an attorney, of course, because you always have to protect your client's information. You have an affirmative duty to protect information. Sometimes it requires filing what we call a motion for protective order. That's something your attorney takes care of. So in those situations, you want to make sure you never talk to somebody without a valid release, regardless if you know the background on it, unless you were the one that was obviously involved specifically in the ERPO itself. If you're the one that filed it, then this stuff's not going to apply because you're the one that's already waived the privilege, essentially. Oh, you're muted, Rachel.
Thank you. I'm always fumbling with that. So let's talk about the big question. You know, what are the professional risks to moving forward? And like I said, the statute really does intend some protections for you, but it's kind of a web of different protections in different areas of the law that overlap, and it's confusing. Like I said, it's not very user friendly. So there are different protections that protect you if you're exercising your duty to warn, versus the ones that protect you regarding the extreme risk protection order process. So because this is so messy, we do encourage you to reach out to an attorney to discuss this if you're confronted with this situation. And then here's kind of a quote of the protective language in the statute. That, you know, it's trying to protect you from criminal, administrative, or civil liability from any person for your decision to file for an ERPO or your decision to not file for an ERPO. There is some language in the statute that if somebody is abusing the ERPO process, that they can be subject to criminal liability. That is when somebody maliciously or files a malicious or knowingly false petition for an extreme risk protection order. So don't do that. Not that any of you would.
And on that note, really quick, that differs from mandatory reporting. So for those of you familiar with mandatory reporting requirements, there's an actual specific criminal penalty that goes into place. It's a misdemeanor that goes into place if you knowingly false or make a false mandatory report of child abuse or neglect. In this case with ERPOs, they actually did not provide any specific misdemeanor or any kind of specific criminal penalty for falsely reporting, which is interesting. I don't know why that's not there. My only assumption is it means it would have to have an underlying crime of some sort. So the only crime I could think of in that regard would be providing false information to a law enforcement officer, which is a class 3 misdemeanor, but that's a whole different ballgame. So I'm not sure what that would look like specifically, but that would be my assumption is maybe they would move forward on that. My thought is that the cops probably would want nothing to do with that. It would be handled in a civil court, but I don't know.
Yeah, and there's also similar language to protect from employer retaliation. So if you do decide or not decide to file for an ERPO, this language is meant to protect you, protect your job, so that your employer could not retaliate against you by firing you or demoting you for your decision. So a few general comments about liability, and this is about really any kind of liability, in my personal opinion, right? When we talk about liability, we can, as lawyers, we can talk about ways that the law protects you, ways that it doesn't protect you, but we can never guarantee that you'll never be sued. People file frivolous lawsuits and frivolous grievances all the time. Again, extreme risk protection orders are a very important tool. I'm very passionate about them, but they are not risk-free for you guys. And so they should probably be a last case scenario. If you've exhausted all of your other options, moving forward with an ERPO should probably be your last step there. There is law that, is intended to protect you that we could hang our hat on and hopefully get frivolous cases dismissed, but we can never guarantee. And so the best practices to protect yourself from liability, if you do decide to file, make sure you're minimizing the amount of information shared with the court. Make sure you're making a calm and mindful decision to file. Make sure, even if you're not subjectively intending to do anything malicious or anything, just keep an eye out for any optics around the situation that might look that way. And make sure you've at least considered these other options for addressing the situation before filing for an ERPO. And so, Jeremy, what would you say, bottom line, the risks of filing for an ERPO? What do you think those are?
The primary one, and this is what we're talking about here, is a grievance to with DORA. And I know, for those of you that have had to deal with this grievance process, it's awful. And it's time consuming. You don't get paid for it. There's no guarantees on the outcome. It depends a lot on the subjective nature of the board that you're in front of whenever you get a grievance or have to file a response to a complaint with DORA. And so that's where I really see the risk here lying, is that you move forward with an ERPO, you provide information for an ERPO, and then you have the client that files a grievance against you saying that you provided their confidential information in bad faith, you shouldn't have done it, there was no threat, it wasn't reasonable. I mean, they're going to go down the line. And unfortunately, what I've experienced with DORA is they don't tend to screen out cases. So even if there's not a legitimate basis to the grievance itself, guess what? You're still going to be stuck having to respond to it, which takes a lot of time. You'll have to contact an attorney, it can cost money. And so that's a big risk whenever you're dealing with these kinds of situations. And that's the problem with the language in this is, they start out minimum necessary information. Well, that's a red flag for me, because that's the basis for a grievance right there. You provided too much information in your report for the ERPO. Second red flag is it had to be reasonable and in good faith. Well, they're going to argue it wasn't reasonable, that they didn't actually make threats, it wasn't specific. I mean, and now you're stuck in this situation of letting, 7 members of a board, 2 of which are public, 5 of which are professionals, depending on the board, make the decisions for you. And it depends on the nature of who those people are on the board. I mean, that's a scary situation. And so that's my biggest worry with this gives mental health professionals just one more thing to be worried about. The important part to remember about this for mental health professionals is this is not mandatory. So it's not like mandatory reporting. This is permissible. My thought on this, and I think Rachel spoke to this very well, is this is for an extreme situation. It's a situation where you're very afraid for somebody and you feel like, hey, this person having these guns on them could lead to real harm. I mean, God forbid that you're in a situation where you're the therapist that sees a client that goes up and shoots up a movie theater or something, and they had talked to you about that beforehand. Guaranteed, regardless if you did what you were supposed to with confidential information, you're going to see lawsuits. We don't want to have that happen. So these are really extreme situations, but that's why if you feel like, hey, this rises to that level, then take the time to talk to an attorney before moving forward with it. Don't make a knee-jerk reaction or decision.
All right. And so this is really more my wheelhouse. I do a lot of protection orders. I'm a trial attorney, and Jeremy does that as well, but he's also the go-to in all the liability stuff. So I'm excited that I can speak with authority on this stuff a little more. So let's say you go through everything, you do your soul searching, you do your talking to an attorney, and you're like, this person, this needs to be addressed. I have to move forward. I understand that there are risks in this process, but I think, as I tell my clients in all my consultations, when we talk about litigation strategy, there's pros and cons to everything. There's pros and cons to acting and not acting, right? And if in your judgment, because we don't have a crystal ball, we can't tell 100% what's going to happen. But if you are really looking at a situation and you say, you know what, the risks of not doing anything are higher than me going forward with this ERPO, I want to do it, then just know that there are attorneys out there who will have your back and will help you with the process, because we also agree that there are situations where, these things need to be addressed with the courts. So this is the process. This is what it looks like if we get to that point.
And Rachel, can I just say this one thing really fast on the note? The ones I really anticipate where the therapist is going to have to take a bigger role is in these sanctuary 2A counties. I mean, that's really it. Because ideally, you would have law enforcement that does the work and goes forward with what they're supposed to do on this. But in those sanctuary 2A counties where law enforcement, specifically sheriffs, say they're not going to enforce these, they believe in gun rights, everyone should have guns, then in those situations, you can't count on law enforcement to do their job. I mean, literally, judges have to hold these sheriffs in contempt for failure to comply and follow through with what they're supposed to do as their duty. So that's what I would just note on that topic.
Yeah, absolutely. Okay, so let's say we're doing it. We're going forward with an ERPO. This is what it looks like. So the first step is completing paperwork. There are 2 forms that we'll kind of get into a little bit. And we have to file those in the respondent's county. So if you're filing in your professional capacity, you have to make sure that you're filing where this person who's exhibiting the behavior resides. Then we're going to go to our first hearing. And so this is something that a lot of people are surprised to hear. I don't know if there's a Hollywood perception or just there's some myth out there that says you can get protection orders or restraining orders just by filing a piece of paper. That's not true. We're talking about a Second Amendment right. There are a lot of due process protections in place for the gun owner to make sure these things are not being abused. And so what that means is we have a lot of procedural hoops that we have to jump through in order to make sure that these are being administered in a fair and objective manner. So we first have a hearing where it's us and the judge. So the respondent is not present typically for that first hearing. I say typically because in theory, if they somehow knew about it, they could show up. I've never really seen that happen, but it's theoretically possible. So 99.99% of the time, it's just going to be us and the judge. The next step would be notice to at-risk third parties, service. So that's where the police officer hand the paperwork over to the respondent, transfer of the possession of the firearms, settlement discussions, and then a second hearing. That second hearing is where the respondent is present and can fight the extreme risk protection order. And then if we win at that second hearing, there are procedures in place for termination or renewal of the ERPO. So let's go through each step. The paperwork. So Colorado has these amazing forms. They're called JDF forms, and they're available for free online. And these are fill in the blank forms that make sure that you're including all the information that the judge needs to see in order to evaluate your case. So you'll kind of go through and you'll fill in, you'll check the boxes, you'll fill in the blanks. The 2 that need to be filed and are filed in most cases are the extreme risk protection order information sheet, excuse me, and the petition and affidavit for temporary extreme risk protection order. So in addition to all of these papers online, there's also a really wonderful instruction manual that you can access online if you have questions, you haven't been able to talk to an attorney yet, you feel like this needs to be filed today. Again, our advice is talk to an attorney if you can, but if you decide to move forward on your own, make sure you're at least going through the instructions that are available online. When you fill out the paperwork, there's going to be a list of factors that you have to explain to the judge, right? And well, it's your opportunity to explain them. I shouldn't say you have to answer every single one, especially as mental health professionals. You should probably avoid answering as many as you possibly can. But the first question is going to be recent acts or threats of violence from the respondent. And the form clarifies The court wants to know about these threats or acts, whether or not such violence or credible threat involves a firearm. So this goes back to one of our previous slides. If somebody's saying, I'm going to hurt somebody, I'm going to harm myself, they don't have to explicitly mention the firearm in that threat. Usually there's some other kind of circumstantial behavior or indications around firearm intent or possession of firearms, something like that, that we see in these cases. But, you know, I wouldn't say ignore it. You know, you can move forward even if there wasn't that explicit firearm piece. The next question is about patterns of violence and threats in the past year. That's going to be one that might get you guys in trouble without having a lawyer present. And then 3 is if the respondent owns, has access to, or intends to purchase a firearm. So the respondent doesn't have to have a firearm. I've seen many cases, many ERPO cases, where we have a respondent, we have a threat to hurt self or others, and there's not a present ability to do it with a firearm. I've seen one case where the respondent said, if I could only afford a gun, I just can't afford one now. I have one picked out, but if I could afford it, I would go ahead and go through with all of this. While that person doesn't have a firearm, they're not necessarily able to get one right away, but the threats were really extreme, and the court did issue an extreme risk protection order in that case. Unlawful or reckless use of a firearm. I've seen several, I think we've had 4 in Boulder County cases that involve reckless use of firearms, reckless discharge. Again, they typically tend to go hand in hand with big substance abuse concerns. If the respondent has a history of physical violence or stalking, abuse of alcohol or controlled substances, the respondent's recent acquisition of firearms and ammo, that's a big one when we're concerned about mass shootings. That's something that the FBI talks about as somebody being on the pathway to violence. And so that's something they want to know about as well. And then the last factor is any other applicable reasons, like anything else that has raised this red flag for you, that you're really concerned about this person's behavior, please include it here. Typically, I see under this factor, I see people talk about diagnoses. We've had several in Boulder County with people with schizophrenia, they're seeing phantom people, et cetera. They're trying to go purchase a gun. We really don't want a gun to be introduced into the situation. And then mental health holds. So you can get an extreme risk protection order even if that person is currently under a mental health hold. You need to make sure that you file in the respondent's county. Just a quick note, if other people are filing, family members and household members have a lot more options for where they can file, but you as a professional, you need to file in the county where the respondent resides. And that first hearing, okay, so let's say we file our paperwork. So within 1 day of filing, we would go in front of a judge. You will need to testify under oath about why you're requesting an extreme risk protection order. The respondent is not present for these hearings. They usually last 15 to 30 minutes. It's relatively quick for hearings. And there is technically an option to avoid the first hearing and just go straight into requesting a year-long protection order. I haven't seen anybody do this yet, but it is technically an option. The downside to that is that the respondent's firearms, they continue to have possession of their firearms in that year, or in the 14 days, leading up to that hearing, that extreme risk protection order hearing. So when there's a risk that needs to be addressed right away, you need to be filing for a temporary extreme risk protection order. And one thing that's unique in Colorado, in our ERPO process, the respondent's always appointed a free attorney. So right out of the gate, the respondent will get an experienced, usually criminal defense attorney, to represent them to, if they decide to fight the ERPO, they can fight the ERPO. So the legal standard that we discussed before is what applies here, but there's also a timing element for this immediate protection order, right? We have to prove that there's a significant risk of causing personal injury to self or others in the near future by having in the respondent's custody or control a firearm. The court, as I mentioned before, may order you to provide more information if it feels like what you provided in your original petition is not sufficient for them to rule on your request. Then they can request more information. And then, if you succeed, if you can meet that burden at the first hearing, then the court will email law enforcement in the respondent's county the paperwork for service. You must call the agency to discuss service. They want to know, law enforcement typically wants to know about anything that might put their officers or others in danger in serving the paperwork. But keep in mind, you're still limited about what you're able to discuss. So that's probably going to be a difficult situation for folks to be in. Law enforcement, depending on the policy of the department you're dealing with, they will either call the respondent to notify them that service is about to occur, or they will show up without notice. That also depends on their assessment of the lethality of the situation. If they believe they need more time, they're allowed to request that from the court. So if you have a patient who was making a threat to a third party, you are requested under your duty to warn, or required under your duty to warn the people who were the threat. But if you get an ERPO, you are required to let the respondent's family or household members know about the ERPO. So that's an additional obligation beyond your duty to warn. So here's the thing that a lot of people have questions about: the transfer of firearms. Like, how does that work? So the paperwork that the law enforcement officers are going to serve, it has this language in it. It says you may not have in your custody or control a firearm, or purchase, possess, receive, or attempt to purchase or receive a firearm while this order is in effect. You must immediately surrender to, and it'll list the name of the law enforcement agency, all firearms in your custody, control, possession, and any concealed carry permit issued to you. So law enforcement, even if they're in these Second Amendment sanctuaries, by law are required, they're required by law to request the respondent immediately surrender those firearms when they hand the paperwork to them. And they must take possession of any firearms that are in plain sight. So if they can see weapons that are out, they must take possession. Any weapons that are surrendered by the respondents, or any weapons discovered pursuant to a lawful search. Once the respondent has been served and the possession of the firearms has transferred, then settlement discussions begin. So if you have an attorney and the respondent, your attorney would talk to the respondent's attorney, and we would say, hey, are you going to fight this? Do you want to keep this in place for 364 days to avoid a hearing? Most of these settle, but not all. They have a higher settlement rate of other types of orders. But we've also seen really strong cases filed up until this point. So never put too much stock in them settling. We always hope that they will, but we prepare for a contested hearing. And I've seen one settlement in Boulder County with provisions requiring the respondents to comply with certain mental health treatments. So that was part of the agreement. Hey, we'll drop the ERPO in 6 months as long as you're going to mental health and you're following all of the recommendations for the next 6 months. If all of that falls through, you have to go to the second hearing within 14 days of the first. This is a full-blown trial, right? This is the respondent and their attorney are present. They may cross-examine you. You may present witnesses. They present with witnesses, exhibits, legal arguments to the judge. At this hearing, you must prove by clear and convincing evidence, that the respondent poses a significant risk of harm to themselves or others. So clear and convincing evidence is a pretty high burden. Most civil courts don't require that high of a burden, but it means we have to have a very strong case before we move forward. And if you win, the ERPO will go into effect for 364 days.
And if I could step in for a second here, Rachel, for all you mental health professionals, if you've been paying attention to this right now, that is a significant amount of time on your part to go through this whole process. You're gonna have to detail your work, write it out, talk to law enforcement. You're going to have to show up at hearings and testify. If you think you're gonna get to charge for any of that, no. So that's another thing to keep in mind in this process, which is why this should only be the most extreme cases that you move forward with something like this.
Yeah, and so if you wanted to seek a mental health evaluation or a mental health hold, an emergency mental health hold as part of the ERPO process, you are able to do that. And I provided, there's a lot of wording around that. And, I don't know if you guys are familiar with that, but it's kind of included in the slides just for reference in case you guys need to read that at some point. And so finally, if you get your ERPO, you've won your case, what happens next? If you win your case, it goes into effect kind of by default for 364 days. The respondent may request to have the ERPO terminated once within that year. We've seen one in Boulder County that was granted, and I was surprised it was granted. So that case terminated even over the objection of law enforcement. In that case, law enforcement was saying, we want this ERPO to stay in place. We don't want this person to have access to firearms. And the judge disagreed. The judge saw that the respondent testified that he had been undergoing mental health treatment, that it was just a isolated incident, that he's really worked on, the issues that led to the ERPO. He also testified that it was he was a gunsmith by trade, and he was unable to work without having access to firearms. And so the court did allow that ERPO to terminate in about 4 months, I think. So that's another thing to keep in mind when you're evaluating whether or not you want to file for an ERPO. ERPOs are typically not permanent. But they can be renewed. So if we have the evidence, right, when that year is approaching, where it's about to expire, at 63 days before that expiration, the court will send out notices to the petitioner and the respondent saying, hey guys, this is about to expire. The petitioner or anyone else with standing may file a motion to renew. So we do that when we have evidence that the respondent is still a danger to themselves or others. So we have to, again, prove our case in front of a judge. So we can't rely on the same information unless it was an incurable mental health disorder. We likely can't rely on the same information that we use to get the ERPO at this point in the process. So an important caveat to this is the original petitioner or anyone else with standing can request for it to be renewed. So let's say, for example, law enforcement went forward with an ERPO, but they're not investigating anything when it's set to expire. I'm not aware of any law enforcement department that is actually actively going out and reinvestigating when it's about to expire. Law enforcement has told me that, hey, if his family and friends don't reach out to me, I'm not going to do anything about making it renew. So let's say law enforcement had an original ERPO, but you're treating that individual, something new has come up that law enforcement doesn't know about. In theory, you could step in, or family could step in, or somebody else could step in and say, hey, we want this ERPO to continue. And it's the same standard as that first ERPO hearing. You have to prove by clear and convincing evidence that that person poses a significant risk of harm. All right. Questions or comments?
Well, this is super terrific, Rachel and Jeremy, and we really appreciate the presentation here. And I think what I've learned here, and I just want to get confirmation, is that it actually has to be my client that's the respondent. If I'm seeing, say, a partner, and the partner is saying that their partner is a danger to them, I actually have no standing.
I'm glad you said that, Andrew, because I was going to speak to that right before someone came to the door. So I had to run and go through that. But yes, that is where I anticipate a lot of this happening, where you have somebody come in and say, my husband, my wife, they've been saying all these things and they have guns in the house, right? That's a scary situation. In that kind of circumstance, you're going to encourage your client to be the one that files their ERPO, because you're right, you don't have standing to file. The only way you'll have standing to file is that it's your client saying it. And I do anticipate that's going to be very, very rare, where you're going to have a circumstance where your client gives you that kind of information. So I think it'll be much more likely that it's somebody else they know about, and that's when you're going to encourage that person to be the one that pursues an ERPO.
However, there seems to be an important exemption when I'm treating the children.
True, and I'm assuming you're talking about mandatory reporting.
No, say I'm a play therapist. I am a play therapist, and I work in high conflict divorce. And I have been treating the child, and it comes to light that there's danger from a parent. I actually do have standing in that case. If I have been seeing the child for more than 6 months, is that the deal?
If you have seen the child within the past 6 months. So even if you saw
Yeah, it
the
doesn't have to
child
be
once,
more. It just means you have
Yeah.
to have seen them at least one time within the past 6 months.
Yeah.
Okay, so play therapists have a little bit more extension here.
Well, yeah, child therapists altogether have more of an extension.
Sure, child therapists.
Yep.
My last question is for couple therapy. So if we're involved with a couple and it comes to light that there are guns and things are going south, that actually counts because we're directly treating somebody in the couple.
That is correct. That would count. Obviously, that arises a whole nother issues of confidentiality because usually it's held by the couple. But you're right. That certainly would give you standing to file.
Okay, super. Thank